Good evening to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Now we are going to discuss a case law on the implication or false implication of an advocate by the police which happened in Rajkot district of Gujarat state. The Honorable High Court of Gujarat, the CJ, Mr. Arvind Kumar, and another Justice Ashutosh J. Shastri, they took very serious notice of the same and initiated contempt action against the police officer. On 14th March, that is just yesterday, 2022, the contender was called to the court, and of course you have to refer this as the case of Bharatbhai. Please remember the name, Bharatbhai Tobanbhai Koyani, only one name, Bharatbhai Tobanbhai Koyani versus Jayendrasinh Udesh Singh Gohil, Gujarati name, right? So this case is in civil contempt application number 331 by 2021. Of course, it was not disposed, it was posted to 14th, and from 14th it is posted to 28th of March 2022. But in the meanwhile, so very strange incident happened. The High Court asked the Deputy Superintendent of Police, Rajkot, to go and seize the general diary dated 21/3/2021 of Zamkhan Dorana Police Station of Rajkot district. Why this happened? We have to know the details of the case. Then only you will be able to appreciate the facts also. Yes, our friend Mr. Bharatbhai, simple, he is an advocate, right? So in Zamkhan Dorana PS, his client was allegedly taken to the police station and he was kept for 1 day in the month of September 2020. He was arrested by the police and he was kept for 1 day, and later only he was released on bail. Of course, the punishment is the case in which he was involved is a very simple case. So the allegation is that the police did not follow the guidelines given in the very famous case of Arnesh Kumar versus State of Bihar 2014. This is the case. Now, the client, after being released from the police station, he approached our advocate, Totabhai, his name is Bharatbhai, and requested him to advise him what to do. So normally, when the police registered a case, you cannot file a case against the police officer. But he is feeling very bad. The client is feeling bad. So he was saying that he was tortured in the police station. So the lawyer advised him to file a private complaint under 156 clause 3. Accordingly, of course, I think the advice on the advice of the advocate, or the advocate would have filed a case private complaint. Drafting a private complaint, normally it will be done by the advocates. He filed a private complaint. A case was registered against the police officer for wrongful restraint or wrongful confinement, whatever sections. Definitely, will the police keep quiet? No. So the aggrieved police officer, that is Jayendrasinh, Udem Singh, like that name. So he registered a case against the client, another case against the client, took him into custody, once again beaten him mercilessly and released him. So the incident did not stop there. So actually, our advocate advised him to go to the higher officers, is one part. But the police officer developed a grudge against the advocate also for giving advice to the client. In the view of the police officer, it is a wrong advice, illegal advice to file a case against the police. But when the client came, the advocate has clearly told him, has clearly guided him, correctly guided him. But it has become the irony of the police officer. So therefore, police officer registered another case against the advocate and his wife, took them to the police station, of course later released them. Now, the advocate filed a case of contempt against the Jayendrasinh police officer. Of course, the High Court asked the police officer to be personally present. He came there. So he said that based on the complaint given by so-and-so, I registered the case like this. Immediately, the High Court asked the DSP, within 1 hour, the general diary should be handed over to the local magistrate. And the local magistrate has to send the general diary to the High Court. The general diary will be perused by High Court and necessary action has to be taken. So that means whether entries were made or not in the general diary is the main question. So just like in that Vakil Salt film, that woman comes, police officer comes from Moinabad to, and she writes 2 or 3 sentences in a very serious case. Like that. The court has to find out whether the GD has been tampered, whether the records were correct or not, we don't know. But anyway, it is a very, very serious issue. High Court ordering the general diary of a police station to be seized means not a simple incident. And that too by the same DSP. Of course, the police officer may be sub-inspector or inspector, I don't know the rank. So, very, very serious case. Of course, if it is proved that the GD has been tampered or manipulated, definitely that SI has to face the consequences of the contempt of the Courts Act. Of course, the punishment is only 6 months and fine is 2,000. But it is sufficient. It is cost his job, is it not? Right. So, Gujarat has become notorious for this. So, actually, when we were police officers, maybe in the year 1989 or so, one magistrate, I think from Patel, some Patel or somebody, he was actually literally assaulted by the police. He was made to drink liquor and he was produced with a medical officer. Certificate of intoxication was taken. Then he was paraded with handcuffs in a rickshaw and he was sent to jail like that. They actually harassed the police. The police harassed that magistrate, judicial magistrate. And it has become a sensational issue. I think it is related to Delhi Judicial Service versus State of Gujarat and others, 1991 case. If I am correct, please refer to that case. You will get the details of the case. In Nadiad of Gujarat, this Patel, actually this Patel was harassing the police. He said that you people are not going to, they are not executing NBWs, you are not able to serve them. Come on, you call the SI. Like that he called them. The SI came and the SI told him, I think that please visit my police station and see the difficulty we are facing. We have got so many other works, not only the court work, Your Honor. So please visit. And innocently this man went to the police station. And I think there the entire incident of dousing clothes with liquor or making you drink liquor, all these things happened. Of course, the police officers were so punished at that time. So better to be careful. If any police officer sees this video, please alert your staff. Do not have a grudge against the common man. So he might have so many grouses. He might have so many difficulties. He might have filed a case. No doubt in certain cases, definitely. We also faced so many private cases, but we did not have any grouse against the person. Either we effected compromise or the cases ended in acquittal. Even in Markapur, a case against me, even though as accused I was not present, the case ended in acquittal based on the merits of the case. So many things do happen. So this is a clear indication that the judiciary will not keep quiet with the dignity, with the right, with the privilege of the advocates. Because advocate is a court officer. If something happens against the advocate, definitely now the court has come to the rescue of the advocate and filed a contempt case against him. So such is the power of the court. And of course, Supreme Court under Article 141 and 140 of the Constitution of India. So please read the case and definitely you will be enriched with the legal knowledge. Thank you very much.